Up.
Yeah?
Yes.
Okay. Good afternoon and welcome to the public meeting of Randwick Local Planning Panel on the 14th of October. Firstly, I'd like to acknowledge the traditional owners of the land and pay my respects to the elders past, present and emerging. I'm the chair of the panel and my name is Annalise Tor. Joining me today via video conference are Julie Sabat-Ward and Garth Patterson as expert members.
Yeah, it's on now.
And the community representative is Kerry Hamer. Today we have 3 people registered to address the panel. Each speaker will be given 3 minutes. Any extension of time will be at my discretion as chair. After hearing from the speakers, the public meeting will be closed and the panel will deliberate and make our decisions. The minutes of the panel's decision, including our reasons, will be available on Council's website as soon as possible after the public meeting. You should be aware that panel meetings are recorded and the audio recordings will be uploaded to Council's website. Can I just ensure that everyone turns off their microphones so that, unless you're being asked to speak, so that there's no background noise. Each member of the panel has been asked prior to the meeting to advise whether they have a conflict of interest to declare in relation to any item on the agenda, and I can confirm that no conflicts of interest have been declared. So the item on today's agenda is D57 of 21, 28 Vicker Street, Coogee. And we have 3 people registered, as I said. The first is Mr. Bishop. Mr. Bishop, if you're there.
Good afternoon.
Good afternoon.
Hello. Yes, I can hear you. Can you hear me?
We're having a bit of trouble hearing you. You were a bit frozen. I think you're okay now. So try again.
All right. Do I commence?
Yes.
Okay. I speak on behalf of the owners of 63 Car Street, Coogee. The owners of 63 Car Street, Coogee support the council staff recommendation that the development application be refused. We also support the comments made by the Design Excellence Panel, with one exception. We do not believe a site setback of 1.02 metres along the southern boundary could ever be acceptable in the scale and bulk of the proposed development. When considered in relation to the orientation of the habitable rooms, private outdoor space and communal outdoor spaces of the property sharing the southern boundary. The proposed development is consistent with the existing character of the area and not in harmony with the existing buildings sharing its boundaries. The owners understand the intent of the R3 medium density zoning and appreciate the site will be developed. We do not expect, or at least hope, some restraint will be provided by compliance with the local environment plan and the development application is an inappropriate attempt.
Mr. Bishop, I'll just interrupt because you are breaking up quite a bit. It might be easier if you turn off your video and just do it, just have it the sound. Maybe if we try that, it might be better quality.
Okay, I usually have good. We'll see how we go.
Yeah, I don't know if it's the same for other.
Is that better? Is that improved or?
Yeah, that's improved. Thank you.
Right. I'll recommence. We do not expect, or at least hope, some restraint will be provided by compliance with the Randwick Local Environment Plan and Randwick Development Control Plan. This development application is an inappropriate attempt to use the Affordable Rental Housing SEP 2009 to circumvent the constraints of the LEP and DCP on an inappropriate site. The proponent requires several merit-based assessments to be made by council or the planning panel. We believe it is not reasonable to ask for merit assessments to develop a constrained site in excess of the limitations provided by the LEP and non-compliance with the guidelines of the DCP, particularly when the development creates unreasonable adverse impacts for neighbouring properties. The proposed development is premised on achieving a penthouse on the 3rd level with access to the northern sun and coastal views. These attributes are achieved without consideration of neighbouring properties and with devastating consequences to the amenity and enjoyment of the properties along its southern boundary. The resulting loss of amenity will depreciate the value of our properties. The cynical nature of the development application is evidenced by the design deficiencies identified by the council staff and Design Excellence Advisory Panel, including the spuriously described landscaped areas, combining portions of the deep soil zone with the patio of Unit 2, the omission of outdoor clothes drying areas, the complete omission of communal outdoor space with the required minimum 2 hours of solar access, the inadequate outdoor areas apportioned to Unit 3 and 4, while the penthouse was originally allocated an outdoor patio of 92 square metres. No thought or consideration being given to the aesthetic qualities of the proposed development in terms of its visual impact on the neighbouring properties sharing the southern boundary. It is apparent the impacts upon neighbouring properties were never considered. The statement of environmental effects at page 78 states the proposed development is considered appropriate and will not be responsible for any adverse environmental impacts in relation to loss of privacy, loss of view, noise, or traffic and parking impacts. And on page 79, the size and shape of the site is suitable for the proposed residential flat building, and the proposal does not create any adverse bulk or scale impacts. The proposed residential flat building will not result in any unreasonable loss of amenity to neighbouring properties. In the subsequent amended DA, the proponent backs away from the prior assertions and refers to the inevitability of lost view corridors and sole access based on the intent of the LEP in terms of floor space ratio and height. Reading the LEP and the DCP, we can see no...
Mr Bishop, I'll just interrupt you. You're over time, so do you need an extension? And if
I probably need 30 seconds.
Yeah, that's fine. Thank you.
Reading the LEP and DCP, we can see no intent stated or implied that neighbouring medium density properties should be not entitled to landscape communal areas with minimum allowable solar access and viable clothes drying areas. We would submit the FSR and height specified in the LEP complement each other in constraining the footprint of a development and consequently providing some degree of protection and equity for adjoining properties. We also make the point the cost of the site and proposed construction costs submitted in the DA show the feasibility of developing the site is readily achievable within the FSR of 0.9 to 1. We appreciate you giving consideration to our written submissions and thank you for your time.
Thank you. I'll just see if there's any questions from panel members. Any questions? No questions. Thank you. The next speaker is Ms. Pelosio. I don't know if that's how you say your surname.
That's okay. Pelosio. How are you?
Pelosio. Okay, thank you.
Thanks, Alice. Good afternoon and thank you. I'm speaking on behalf of 55 to 57 Carr Street, which is a 20-year-old building with 8 apartments on a double block directly south of this proposal. I would like to open with the fact that I support increasing density of our areas that have high amenity, and I support the need for affordable housing. However, if this grossly overdeveloped proposal is seen as a model for how these important things are achieved, then it will drive these initiatives completely backwards, as it is a development that thinks just about itself and has no consideration whatsoever for its neighbours or its context, and 2, a development that makes a complete mockery of provision of affordable housing, squeezing every inch of development out of a site for the benefit of one meagre affordable housing unit, which will only be guaranteed for 10 years, is outrageous. And not only that, but they have cooked the books, so to speak, on designating the largest of the 2-bedders as the affordable unit so that they can reach the 20% GFA target. This is highly disingenuous. The proposal is, to put it quite simply, grossly overdeveloped. Increased FSR provisions for this area is not intended to be achieved on a single residential lot. As multiple precedents have shown, it requires at least 2 lots to enable a sensitively designed development which doesn't crowd site boundaries, overshadow neighbours, impact privacy of private gardens, courtyards and living areas, nor wipe out every bit of vital deep soil for mitigating urban heat, supporting biodiversity, and enabling water-sensitive urban design. This developer has the gall to call its rear boundary to the south a side boundary. It's not a side boundary, it's a rear one. And to think that they can get away with a 1.02 metre setback that results in a Part 3/4 story building looming over its neighbours and impacting their view removing their son is disgraceful. This will set a very dangerous precedent for densification done badly. When we need to densify in tight urban areas, we need to do it well, and we need to do it respectfully. We need to be setting good benchmarks, not establishing appalling ones. One addition to Peter's point is view sharing, which has not been fairly considered as it relates to DCP section C2 5.5. The gross overdevelopment of the block results in significant view loss to the north and east for 55 to 57, as well as others, including 61 and 63 Carr Street. As final comments, I'd like to say that if approved, the project will have a catastrophic impact to our amenity and the value of our homes. And it would also set a dangerous and disgraceful precedent. We need to densify and provide affordable housing with sensitivity and respect to the place and to neighbours. Projects need to think beyond their boundaries, and this project thinks purely about itself, and I reject it wholeheartedly, as do the other members of our apartment building. Thank you very much.
Thank you very much. Any questions from panel members? Oh, all right, thank you. On behalf of the applicant, we have Mr. Anthony Betros.
Good afternoon all. Thank you for the opportunity to speak before you. I hope you have received our response to the LPP, which was a request for deferral. Thank you.
Yes, we have seen that.
Thank you. In my opinion, we can address a lot of the issues that are raised as reasons of refusal, particularly in relation to the amount of affordable housing, and that can be achieved in an amended set of plans, and the architect is already in the process of preparing those. I think I've addressed most of the reasons of refusal, particularly in relation to setbacks and also in relation to amenity impacts. I think you would acknowledge that the height is actually very modest in relation to the height controls, given that we're actually below the wall height and no part is over the wall height when viewed from the neighbours to the south. The views are accessed over a side boundary, and therefore any sort of impacts are inevitable. We did make an offer to do a view assessment during the process of the DA, and we'd be more than happy to do that as during the deferral period if possible. I hope you've had access to the 3D view from the sun diagrams as well, which show that the neighbouring buildings, even the ground floor dwellings to the south, will in fact retain more than 3 hours sunlight on June 21, which on an east-west site in an R3 zone with a wall height of 10.5 and overall of 12, that's, I think, a very reasonable outcome. I'm happy to really answer any questions if you have any. I still stand by that the application is an appropriate response for the site. It meets the minimum site area for affordable housing. We're taking up the 20% and is an appropriate design response. We also did make some quite significant amendments contrary to what was in the assessment report following the Design Excellence panel. And on the latest set of plans, you would have seen the outline of the submitted application and how the building has been pulled back to provide a greater setback when viewing up Vicar Street from north down to south. Happy to answer any questions. Thank you.
All right, well, I'll start. So we've had a very quick look at the amendments that you've put in. And I suppose just things like the council officer's report talks about setbacks. And as I understand, your position is that the ADG, setbacks in that relate principally to privacy and therefore you don't need to set it back further. And I think you implied that it complies with the setbacks in the DCP, and there are plenty of examples nearby of areas of other recent 3-storey flat buildings that have similar sort of approximately 1 metre setbacks. Is that correctly stating what your position is?
Exactly correct. If you go up and down Arden Street on both sides, there are numerous instances of those residential flat buildings which are actually 3 and part 4 stories, as well as the examples that are quoted in relation to the communal open space variations. Each of those examples at 115 Dolphin Street, that was also had 0.9 metre side setbacks, and those other examples at Arden Street. I could name many more as well. And that was in fact acknowledged in the excerpt of the court judgment from 191 Carrington Road, which was also on a 13-metre wide site and had a single-storey semi-detached dwelling south. And there were shadow impacts, and the Commissioner in that case found those to be inevitable and not born from poor design or any non-compliance.
Okay, so you're saying characteristic of the area is 3-storey walls that are 1 metre from a boundary.
Correct, and that's consistent with the application of the DCP.
And what is the control in the DCP? Sorry.
But the DCP has a sliding scale. There's no minimum lot size. It's based on the frontage. So below 12-metre frontages, it's merit. 12 to 14 is 2 metres. 14, then it goes up as the sites get wider.
Okay. And then in terms of affordable housing, you're addressing that how? How would you address it in terms of you accept that as currently proposed, it's 17% or 17.9% of GFA?
Well, there was a difference of opinion in terms of the calculation of floor space.
Yeah.
I understand that Council's officer said that the common stair, which is excluded, we say, as communal common circulation, is included because for the uppermost level, because it's only servicing the penthouse. Whereas we said on a strata plan, that would be common property, and also for any visitors going up, that would be excluded by way of being common circulation space. But notwithstanding, our client is prepared to ensure that more than 20% is provided in the amended plan set.
All right, but you're doing that how? By making that apartment bigger, or
Nominating 2 units.
Nominating 2 units.
Correct.
Okay. And then my final question is, in terms of the extent of changes and the potential that they may not address all of the concerns, why is it? What's the utility of doing it as a deferral as opposed to coming back with an 8.2 review?
I think because we're so close, from a principal perspective, this application's been lodged almost 12 months ago, and the first we heard of the going from approval to refusal was in the notice of the LPP. So I don't think we've already made a set of amendments. We weren't told that they were inadequate or inappropriate, and we felt that the opportunity to provide the view analysis and address the affordable housing proportion and those other items relating to bicycle parking, clothes drying, etc., could address the reasons of refusal.
All right, thank you. Any questions from panel members? No?
Yes, I have a couple, if I might.
Yes, thank you.
So the view analysis, there was no view impact analysis provided with your application. I just heard from you now saying you offered to do one. Why didn't you do one in the first, when you prepared the development application?
Well, we're under the height, and in terms of going through the process of getting access and those, it's quite difficult. But in instances where there's a view over a side boundary and under the height limit, in my opinion, any view impacts are sort of inevitable. But we offered to do one during the process. We actually weren't sure what impacts there would be because of the terrain there and the distance from the coast, and also the amount of buildings in the foreground between the affected properties and the coastline.
Yes, your comment about that you weren't sure what the impacts would be is the reason why I ask. So you did offer to do one, and council said it wasn't required. What
Correct.
Was the issue? Right. Okay.
That was during the DA. After we received the objections and we had access to the photographs, we offered to go into the properties. I'm not sure if it was because of COVID or...
Oh, yes, okay. Yeah, COVID probably did prevent things. All right. And you were saying in your amended plans that you've just prepared recently, you understand that you've resolved council's issues to do with setbacks and amenity. How have you resolved those?
No, I've said resolved in relation to issues such as storage, motorcycle parking, clothes drying, and private open space. I think there was a link between FSR non-compliance and impacts, and I've said I didn't agree with some of I think they're resolvable, or I didn't think they were justifiable, particularly in light of that recent decision in relation to setbacks. If you've had access to our submission, that the way the setbacks have been applied is based on the DCP, not ADG 6 metre setbacks on sites of this nature.
So your setbacks haven't changed, and you're saying because it's part of the character of the area as such?
More so in relation to it complies with the DCP.
Okay.
Well, as I understand, though, sorry, the DCP it just says on merit. So
correct.
It's not like there's a numerical compliance. It's on merit. So.
But in terms of meeting the objectives of the control, and also when you look at a 12 to 14 metre site requires 2 metres, and under 12 is on merit. So in each of those addresses listed at 115 Dolphin, 162 Arden, 161, 163 Arden, each of those have 900 mil setbacks on sites which are 12.19.
And when did you understand there was a disagreement between yourselves and council in terms of the calculation of FSR?
When the report came out.
Okay. So you didn't provide a clause 4.6 written statement because you believed you were under.
We thought we provided the 20%. Yeah. Yes, correct. We thought we had provided the 20%, and there was a discussion about the walkways, whether they're breezeways or not, and we accepted. We just went for the conservative route that they would be included, notwithstanding the recent Mossman judgment, which excludes non-weatherproof areas. But in any event, our client is happy to provide 2 affordable units just to address that issue more or less in terms of avoiding any issue with what's in and what's out.
And just to your question of deferral, I'm not speaking on behalf of the panel. We will discuss this later. But if the panel was of a mind to defer, what would be the time frame you would need to address these various issues put forward by council?
I've got draft plans attached to that document, so it would be within a week.
So you're saying your draft plans address all of the issues and reasons for refusal?
There are just some tweaks to get the GFA correct, and also I think one of the private open space areas had to be updated just to make sure it met the DCP amount in one area.
Okay. Thank you, Annalise. That's all the questions I have.
All right. Any further questions? No. All right. Thank you, Mr. Batros.
Thanks very much.
So that, as I've said in my opening, that the public meeting will now be closed, and the panel will deliberate and formulate our decisions. Our decision and the reasons for that decision will be published on Council's website as soon as possible. So the public meeting is closed at 1:26. Thank you.